The Supreme Court today stopped short of legalizing marriage equality, but stressed that an individual's right to enter into a union cannot be restricted on the basis of sexual orientation. The 5-judge bench came up with 4 judgments differing primarily on the question of adoption rights for the couples. The judges asked the centre to proceed with the formation of a committee to address practical concerns of same-sex couples, such as getting ration cards, pension, gratuity and succession issues. The centre had on the 3rd of May told the court that it plans to form a committee headed by a cabinet secretary to explore administrative solutions to problems faced by same-sex couples without delving into the marriage equality question.
The government will constitute a committee chaired by the cabinet secretary for the purpose of defining and elucidating the scope of the entitlements of queer couples who are in unions. The committee shall include experts with domain knowledge and experience in dealing with the social, psychological and emotional needs of persons belonging to the queer community as well as members of the queer community. The report of the committee chaired by the Cabinet Secretary shall be implemented at the administrative level by the Union Government and the governments of the states and the Union Territories. Despite vehement opposition to any departure from practice, the institution of marriage has changed. This is an incontrovertible truth. Here it is also important to take note of the fact that these changes were brought about largely by acts of parliament of the legislatures of the states. While the passage of many laws was preceded by significant social activism, it was the legislature which ultimately responded to the call for change. Even as parliament and in some cases the courts expand the liberties of the people to conduct their lives in a manner they see fit in accordance with law, many sections of society remain opposed to these changes. Regardless of such opposition, the institution of marriage has undergone a sea change. It is therefore incorrect to characterize marriage as a static, stagnant, or unchanging institution. Homosexuality or queerness is not solely an urban concept, nor is it restricted to the upper classes or privileged communities. People may be queer regardless of whether they are from villages, small towns, or semi-urban and urban spaces. Similarly, they may be queer regardless of their caste and economic location. Persons may or may not identify with the labels queer, gay, lesbian, trans, etc., either because they speak languages which are not English or for other reasons. But the fact remains that many Indians are gender queer or enter into relationships with others of the same sex. When Regulation 5.3 is understood in the light of this position, a queer person who is in a relationship can only adopt in an individual capacity. This exclusion has the effect of reinforcing the disadvantage already faced by the queer community. The law cannot make an assumption about good and bad parenting based on the sexuality of individuals. Such an assumption perpetuates a stereotype based on sexuality that only heterosexuals are good parents and all other parents are bad parents, which is prohibited by Article 15. This assumption is not different from the assumption that individuals of a certain class or caste or religion are better parents. In view of the above observations, the adoption regulation is violative of Article 15 for discriminating against the queer community.
There exists an unqualified right to marry, which requires treatment as a fundamental freedom. We agree on this conclusion arrived at by the learned Chief Justice and his analysis of all these cases, that the Constitution does not expressly recognize a right to marry. While we agree that there is a right which we characterize as a right to a relationship, the queer couples and other relationships of that kind can have a union. We characterize it as a right to relationship to avoid confusion. We squarely recognize that it falls within Article 21, as already recognized in these cases. The right to relationship here includes the right to choose a partner, to cohabit and enjoy physical intimacy with them, to live the way they wish to, and the other rights that flow from the right to privacy, autonomy, and dignity. They are, like all citizens, entitled to live freely and express this choice undisturbed in society.
I think it's extremely disappointing that the buck is passed on to the legislative. Sometimes you think that you've spent a lifetime waiting, And again, now you're waiting and you're at the mercy of people who are primarily, a lot of them are homophobic, you know. My life is dependent on judgment where no one from my community has any say in what the judgment would be. You know, there is no representation.
जो LGBT समुदाय के लोग हैं जो इतनी हिम्मत कर सकते हैं कि मीडिया के पास आएं, हम हमारे MLA और MPs के पास भी जाएं और उनको बताएं कि हम उतने ही अलग हैं जितने कि 2 लोग अलग होते हैं. हम में कुछ हम ऐसा नहीं है कि हम में कुछ कमी है, हम बस अलग हैं और विविधता है हम में. बट इसका मतलब ये नहीं कि हम बीमार हैं या आप हमारे खिलाफ कुछ कह सकते हो. ये जो मैरिज इक्वालिटी है ये शुरुआत होगा बहुत सारे राइट्स का. तो हमने 2 कदम आगे लिया है, 1 कदम पीछे लिया है.
I heartily welcome the verdict. I heartily welcome this observation, and I want to respect the differences. I think it's a long way to go. We are a struggling community. We are facing so much of challenges. There are still so much of hurdles coming through. It's an appropriate time for India to legalize marriages of the consensuality, willingness, and with consent.
It is a very disappointing day because India is so behind. The sad part is some privileged cis man get to decide on what the minority, which is generally the less than 10% of the population, whether they can marry or not.